Uh, Thanks. And ladies and gentlemen, it's my privilege to be invited here to speak on this subject. Never mind what the topic is given in the schedule. The real topic is, as you see on the screen, that is, I'm going to provide you a view into the Water Dispute Tribunal from inside the courtroom, from the witness stand, and so to say, from the war room. Also, I would like to confess at the beginning that I might exceed the time limit by maybe about 15 minutes. The reason being that everything that I wanted to say couldn't be compressed in one session of 45 minutes. Of course, I was given the option of having two sessions, but then if you break it in between, then the entire momentum is lost. So I thought I would reduce some of the content, exceed the time a little bit so that I have everything in one go, right? Now, what happens is that most of us, and particularly those of us from the CWES, rarely have an opportunity to know what actually happens inside a river water dispute tribunal. The reasons for that are many. While we are in service, we have to be neutral and we cannot participate in the tribunal process in any manner. The courts in India are all open courts and one can go and attend a tribunal proceeding on any day. There is no problem in that. But you really can't appreciate or absorb anything. You can't really grasp anything by attending the process or the proceedings for a day or so. You really have to be in it, so to say, to be in the battlefield. Fortunately, I got that opportunity. I have been advising Goa for the last I have been advising Goa for the last 7 years. 1 minute. For some reason, the slide is not changing. Yeah. So we are going to go today a little beyond the theoretical view. During these 7 years with Goa, I was not only advising them, so to say, on the matters like hydrology or water resources engineering, but I was right in the middle of the battle. Every hearing, every single hearing was attended by me. Every paper that was submitted to the tribunal, no matter what affidavit or IAM or whatever, some of them were drafted by me, some were, all others were ratified by me. Similarly, I have been consultant to government at Chhattisgarh now for 2 years and continuing, and there also I am playing a similar role. And this has given me a certain insight which I wanted to share with you all. Focus is, of course, on how can we improve the resolution of the interstate water disputes. But to do that, I have to first tell you what is the process, because not everybody here may be familiar with the process. Those of you who are from a state government might have had an opportunity to participate in the tribunal proceedings on behalf of the state government, but even that number may not be very large. And those of you who are from the CWES are very likely not have had an opportunity to see the tribunal process from the inside. So while the focus is on how can we improve the resolution, the first I have to spend about maybe 15 to 20 minutes in describing what is the process. Only then we can understand where are the deficiencies, so to say, and how can we improve upon them, right? So I believe the speakers before me have covered the story up to constitution of a tribunal. A state submits a complaint and then the Ministry of Water Resources has to satisfy that it cannot be resolved by amicable solution, etc., etc., and the tribunal is constituted. 3 judges are appointed, 2 assessors are appointed, and they get all the office and everything. What next? That is where my story starts. What next? The MOWR refers the complaints received by them to the tribunal for adjudication. Complaint may be one or more. Even though the tribunal may be constituted initially on the complaint of one party, but later on other parties are also welcome to submit their own complaints. In fact, in case of Mahadai, that is Mandovi, as it is called in Goa, the MOWR formally asked all other states that we have received a complaint from Goa. We were the original complainant. But in case you have any complaint, you can also submit your complaint. So this is a situation where there isn't one complainant and all others responded. Everybody is a complainant, everybody can be a respondent. While this is called the main matter, the complaint which is forwarded by the ministry to the tribunal for adjudication is called the main matter. Usually it's a very simple two-line reference which says that the reference is forwarded hereby for adjudication of all matters arising from it. This construct is very important. All matters arising from it means tribunal is given a complete jurisdiction on any issue pertaining to the water dispute in that basin. Simultaneously, the parties may also apply to the tribunal for some interim relief. These are called IA or interlocutory application. Interim relief is a relief granted with inadequate scrutiny. The basic logic is that, look, I am asking for 100 MCM of water, but I know that the way the process is, deciding that is going to take maybe 5 years. But I am having acute scarcity. Therefore, while the main matter is being heard, please grant me, say, 5 MCM as an interim relief. This is called an interim relief. Naturally, if you scrutinize the merits of the interim relief with the same level of scrutiny as you would do for the main matter, then that is also going to take 3 or 4 years. So obviously, interim relief is a relief on which a decision is taken, whether granted or not granted. But a decision is taken with inadequate scrutiny and may be given if the party establishes 3 basic principles. Number 1, they have to prove that there is a prima facie case for seeking that interim relief. Number 2, grave and irreparable injury if the relief is not granted. And number 3, balance of convenience in their favor. Now, balance of convenience is a legal term. What it means is that A says that give me 5 MCM of water now, otherwise I am going to die. B says if you give him 5 MCM of water, I am going to die. So both are saying that they are going to die if the decision is taken either way. So how does the court decide? Now, whosoever's arguments seem to be more convincing, the balance of convenience is said to be in their favor and relief may be granted. 2 other things that the court may look at is that interim relief should be much less than the final relief. This is obvious. If supposing by final relief I am asking for 100 MCM, and in the interim relief, if I say that please give me 80 MCM as a interim measure, that doesn't make sense. If I get that 80 MCM, I might lose interest in the rest of the case. So the interim relief should be much less than the final relief and shouldn't create a fait accompli. If I say that as an interim relief, allow me to construct a certain dam, and supposing the court allows it, but later on the court feels that the dam was not actually permissible, but then I will say, oh my God, I have spent 5,000 crores of the public money, now it will all go west. So the interim relief should not create a fait accompli. Subject to these conditions, the court may grant an interim relief and the trial for interim relief goes in parallel simultaneously with the main matter. The process is more or less same, except as I said, the scrutiny level is slightly less. So we are going to discuss hereafter the process followed in the main matter. As soon as the tribunal takes charge, each party is required to write a SOC. This abbreviation we are going to use often. SOC stands for Statement of Case. Basically, this is a statement in great detail, and I'm going to come to why is it in great detail, which outlines the facts of the case, the defenses of each party, and finally, what are their prayers. The prayers is extremely important. At the end of it, you have to say specifically what relief you want from the court, right? So every party is required to submit a SOC. Now hereafter, nothing can be submitted by one party to only one other party or only to the tribunal. Everything has to be distributed in a kind of broadcast mode. Anything that any party submits to any other party has to be, copies have to be given to all the parties and simultaneously. That goes without saying. No special application is required for that. Then A writes a SOC and B writes a reply to A's SOC. And then A writes a rejoinder to that reply. Clear? A writes a statement of case. What is their case? B replies to their case. A again writes a reply to the reply, which is called a rejoinder. Similarly, B also writes a SOC. A writes a reply to the B's SOC and B writes a rejoinder to the reply. Now, for the simplification, I am taking a case where there are only 2 parties, but there could be 3, 4, or 5 parties, like there were, let us say, in Krishna, Karnataka, Maharashtra, Andhra Pradesh, etc. There could be more parties. The same logic applies there also. If A writes a SOC, B and C both have to write a reply to that, and A has to separately write a rejoinder to the B's reply and C's reply, and so on. So there are a large number of such documents pile up. Together, these are called pleadings. Everything written by A, that is his own SOC, his rejoinder to the reply by B, and his own reply to the B's SOC are called pleadings of A. Similarly, Mr. Karunakar, could you please mute yourself? The participant by name J. Karunakar, kindly mute, or the host may kindly mute. Similarly, B writes his own SOC. Then, in fact, I suggest that the host should mute everybody except the speaker till we come to the question hour session. Similarly, B writes his own SOC. B writes rejoinder to the reply given by A, and B also writes a reply to A's SOC. These are called pleadings of B. Now, this pleadings is an important stage, and it has got multiple and very crucial purposes. The first purpose is to prevent the cases from being expanded or grounds being shifted during the trials. See, what happens is in civil suits, and interstate water dispute is a civil suit. In civil suits, typically one of the parties will benefit by continuing with the status quo. Now, if you are allowed to add newer issues after the trial has started, then the party who stands to benefit by continuing the status quo will go on adding newer and newer issues, and the trial will never end. I had listed 5 issues. The trial has started. 3 years have passed, and just as it seems that the trial is coming to some conclusion, I will add 2 more new issues. Again, the whole cycle will start. Again, when it seems to come to a conclusion, I will again add another issue. Now, this obviously can't be permitted. Therefore, first part of the pleadings is to prevent the cases from being expanded or grounds being shifted during the trial. And how is that achieved? There are some rules, or you can say law or decisions of the Supreme Court which are sacrosanct and they have to be observed. No party can submit evidence on an issue which is not raised in the pleadings. That is very clear. Whether the issue you raise is right or wrong is not the question at all. Supposing, for example, that climate change has a significant role in whatever my prayers are, but I did not raise the matter of climate change in my pleadings. Now I can't raise it later. Even if I raise it by some surreptitious manner, I am not allowed to submit any evidence on the matters of climate change. Whether climate change is really there or not there, what way it is going to affect the hydrology is not the issue at all. If I wanted to say anything on the climate change, I should have mentioned it in my pleadings. If I don't mention it in the pleadings, I can say it later on. Second, the court also has to confine its decision to the questions raised in the pleadings. That is, even if supposing by back door I introduce the matter of climate change. Say I am submitting an affidavit on the 75% dependable flow, and in that affidavit, I introduce some talk about climate change. But even then, the court has to confine its decision only to the questions raised in the pleadings. Court cannot give a decision on anything which is not raised in the pleading. And third, the court cannot grant a relief which is not claimed and which does not flow from the facts and the cause of action as alleged in the plaint. Plaint actually is a legal word, actually it means complaint. Now, initially in the SOC, I said that the SOC contains all the case, statement of the case and defenses, and in the end there are prayers. So whatever you have not prayed for cannot be granted in the relief. So obviously, if you have not mentioned climate change in the pleadings, have not made any prayer pertaining to climate change, then no relief can be granted on that. So by these 3 devices, the pleadings ensure that the case cannot it freezes, or you can call it kind of prescribes a syllabus to the trial. You can't go outside this syllabus. That is one part. Second part is to ascertain the main points on which parties are having a dispute. So these are called issues of dispute. This is something similar to, you can say, charge sheet in a criminal case. There may be so many accusations, but eventually there is a charge sheet and the trial is confined to the charge sheet. The civil equivalent of that is issues of the dispute. Eventually, tribunal will cull out, will extract some issues, main issues on which there is a dispute, and thereafter the trial will be confined to these issues only. Third is fair trial. Opponent should not be taken by surprise. This is not a game of chess. This is not a game of chess where you spring a surprise move or your opponent at some time and try to win. There has to be a fair trial. That means your opponent should know beforehand what is going to be your, you can say, complaint, or what is going to be your defense, and the opponent should be given an opportunity to prepare for his own argument. So through the SOC, each party gives notice to the other party as to what their case is. Clear? So like that, the pleadings are completed, which is the SOC, the reply to the SOC, and rejoinder. After the pleadings are completed, now what is this SOC? SOC is a very exhaustive statement of case. Now, I told you just now that once the SOC is final and submitted, you cannot go outside that. Therefore, the tendency is to stuff everything in the SOC, irrespective of whether you think it relevant or not relevant. Now, you cannot prove anything which is not in the SOC. But the converse is not true. You are not obliged to prove everything which is there in the SOC. So suppose in the SOC, you made a reference to climate change and impact of climate change on the hydrology. But later on, when you took up the hydrology analysis, you found that climate change actually doesn't have much impact. Now, having mentioned it in the SOC, you are not obliged to bring in climate change. If you want to ignore it, you can ignore it. Therefore, the tendency is that in SOC, you stuff everything because you never know later on what might be relevant or what may not be relevant. If something is irrelevant, you ignore it. Okay. What is the reply? The reply is standard, typically just deny everything. Reply normally doesn't become much voluminous. SOC can be typically 500 pages or more. Now, one of the reasons, of course, is that in court proceedings, we use the Times New Roman 14 point and double space. But that apart, margins are also wide, but still it goes into 500 to 600 pages. Reply typically denies everything. If I say that a 75% dependable yield of the catchment is 100 MCM, my opponent will typically say it is hereby denied that the 75% dependable yield is 100 MCM, and so on. He will just go on denying everything, and my rejoinder will typically reiterate everything. So I have said the 75% dependable yield is 100 MCM. In the reply, the opponent says it is hereby denied that the yield is 100 MCM. In the rejoinder, I will say it is hereby reiterated that the yield is 100 MCM. Now, this serves a legal purpose in the sense that everybody has been given an opportunity to be very sure as to what their stand is. Now, you can't say later on, oh, by mistake I wrote that, etc. So this is the typical form of the SOC, the reply and the rejoinder. Now, once the pleadings are completed, then we enter the next stage. There are two things now. One is called the issues and other is called the interrogatories or the discoveries. Now, let me take up that interrogatories part first. Now, see, what happens is that every party has to do two things. Number one, prove their own case. Number two, find flaws in the case presented by the opponent. Now, usually any flaw or any challenge that I might pose to the case presented by my opponent will require data which is in my opponent's territory, right? Supposing my opponent says that I am irrigating 1 lakh hectare from such and such barrage, and I am growing such and such crop pattern and I therefore require so much water. But now that barrage, the command area, everything is in my opponent's territory. So how can I challenge him unless I have the data? Therefore, this stage of interrogatories or discoveries allows each party to raise any number of questions seeking any data, documents, everything from the opponent's side. This is somewhat like RTI. It's not like a parliament question. If you don't have a document, you are not required to answer why you don't have it. But if you have it, you have to provide it. And you have to provide the correct and truthful information. In case you do not provide the information despite having it, or if you give incorrect information, then that's a very severe offense. It is perjury. Perjury means deliberately trying to mislead the court. And a river water dispute tribunal has all the powers available to a civil court. And perjury is a serious offense, can have serious consequences for the state or for the person concerned. So nobody would do that. So each party can seek information or data from the other side, and if they have it, they have to give it. So if you ask a DPR of a certain project from me, and if I have the DPR, I have to give it. But if I don't have the DPR, then I don't have to prepare DPR because only you have asked for it. I can simply say I have not prepared the DPR, right? So this goes in parallel on one side, and of course the interlocutory application for interim relief are simultaneously going on the other side. Now let us come to the issues. Now in the SOC and the reply and the rejoinder, parties may have said various things, so many things. Now if you really start adjudicating on each of them, then it will take a very, very long time. Therefore, what the tribunal tries to do is, with the help of the two assessors, who, as you know, are senior engineers, usually from the CWC, not necessarily, but usually from the CWC. So with their help, the tribunal extracts some very important issues on which there are dispute and which need to be adjudicated. These issues are, first, the parties are also allowed to submit the issues. All parties may submit the issues. All parties may comment on each other's issues. And eventually, the tribunal first makes a draft issue. And a hearing is held in open court. The tribunal circulates the draft issues. the parties may suggest modifications. They may want to add some issue. They may want some issue removed. They may modify the language and so on. And after all that is done, then finally, some number of issues remain. And then thereafter, the trial is confined to these issues only. Typically, the issues may range anywhere around 50 or so. In Mahadai, there were 76 issues. In Mahanadi, also issues have been framed, and there are 46 issues, right? So typically, these issues are formed, and they take the language. Now, every assertion that is denied by a opposite party gives rise to at least one issue, perhaps two issues. See how it goes. A in the SOC has said that Tapi is a perennial river. I'm deliberately going to take examples like Tapi or whatever, which is not in any tribunal, so that I'm not accused of making comments on a tribunal which is under progress. Okay, there is no tribunal on Tapi yet. A says in the SOC that Tapi is a perennial river. B says in the reply it is denied that Tapi is a perennial river. A in the rejoinder says it is reiterated that Tapi is a perennial river. Now the issues framed could be: does A prove that Tapi is a perennial river? Does B prove that Tapi is not a perennial river? This is one way of framing the issue, where both parties are clearly told independently to prove whatever they have said. Alternatively, the issue can be framed as a question whether Tapi is a perennial river. Now A will submit evidence that it is, B will submit evidence that it is not. So this is how the issues are formed, and typically they start with either the word whether and end with a question mark, or they start with does one of the parties prove and then some statement, right? So every assertion which is denied by another party gives rise to at least one or two issues. Once the issues are framed, then you have to prove them. How do you prove them? You submit evidence. So A will submit a hydrology study to prove that Tapi is a perennial river, and the expert who did that study will appear before the tribunal as a witness. There is a cross-examination. B will cross-examine A's witness. Every study that you submit to the tribunal has the status of a sworn affidavit. There is no such thing that, oh my God, sorry, I made a mistake. Nothing like that. It's a sworn affidavit, and in fact, there are two parts. One is the affidavit and one is the report. The study itself is the report. The affidavit says, I, Chetan Pandit, son of so-and-so, resident of so-and-so, hereby swear and affirm, and it is notarized, etc. And my study and my conclusion are annexed as report. And therefore, that report gets the same status as a sworn affidavit. Having submitted that, I have to present myself as an expert for cross-examination, where B cross-examines A's witness, and likewise A will cross-examine B's witness. Now, this is a very interesting thing, and I'm going to speak at length on this later on. Basic purpose of cross-examination in law is, first is you try to see if the witness can be made to admit anything which is to your advantage. Now, supposing I am B, or I am A. So I am the hydrologist who says Tapi is a perennial river. Now, B's advocate will try to see if somehow I can be myself made to admit it's not a perennial river. That is the best thing. If the opponent's expert admits something which is to your advantage, that is the best evidence you can have. If not, and that is usually not possible because experts are good experts, they don't make such mistakes. So if not, then the advocate will at least try to discredit the study. And this is where many of the problems arise. So we'll go into that in the detail. After the cross-examination by all the advocates is over, for example, when I stood as a witness on behalf of Goa, I was first cross-examined at length by Karnataka, then by Maharashtra. And when the advocates of all the parties have finished, judges may also put some questions. But that is not called cross-examination, because a witness in the eyes of the law is an officer of the court. For that duration, he is an officer of the court, and he is there to help the court reach the truth. So judges may also put some questions. Now, this is where the trial ends. After all the cross-examination is over, that is, all evidence recording is over, the advocates of each side make oral arguments. The oral arguments are there to really cover what could not be covered in the cross-examination. And the oral arguments made are supported by written text, because usually the oral arguments are quite detailed. They may go over more than one day. That is, one advocate in his final argument may speak 4 hours a day, 11 to 1, then lunch break, then 2 to 4, and may speak for 2 days, 3 days, etc. Obviously, it is not possible to remember all that for the judges. Not only that, the advocate also has to be careful that he doesn't miss out anything. Therefore, typically, they don't speak extempore. They will read out from a written statement. If you saw on TV the trial in the Hague court where Harish Salve presented our Kulbhushan Jadhav's case, he such a erudite speaker, one of the topmost lawyer, but he completely read from a prepared written statement. Okay, so it is submitted as a written text, and here the trial ends. The trial ends. The court now adjourns, analyzes all the evidence, evaluates it, and finally comes out with a report. We call it an award, but actually that is not an award. The word used in the law is report. The tribunal sends a report to the MOWR. MOWR notifies the report in the Gazette, and only then it becomes an award which is final and binding on all the parties. But the parties are allowed to seek clarification, which the tribunal may give. Now, here I have finished the part 1 of my presentation, that is what the basic process is. Now let us see how it can be improved. Now, to understand how it can be improved, I may have to make a few critical remarks here and there on the process, though that is not the intention. The intention is to, of course, improve the thing. And in any case, I do not have the, you can say, the power or the authority to be critical of what the law is. But then unless we say that this can be improved, we have to say that we have to first see if there are some flaws in the existing process. So that should be taken in the appropriate spirit, right? There are two types of litigations. The various countries in the world follow two different types of litigation processes. One is called adversarial litigation, where the opposite sides are adversaries who compete to convince the judge of their view, and the judge is an impartial referee. The other is called inquisitorial litigation, where the judge conducts an inquiry into the case. So the judge is not limited to merely hearing the submissions of the parties. The judge can direct the lawyers to address specific points, can ask the advocates to submit particular evidence if not submitted, call particular witnesses, etc. Okay. Look at the box below. The USA, UK, India, they all follow the adversarial method. Whereas most of the mainland Europe, France, Italy, Germany, etc., they all follow a inquisitorial method. Now, because we follow, this is come, there are two basic systems of law called civil law and commons law. So we follow what is called this law where the litigation is adversarial. Now, many of the problems in this process arise by the fact that here the parties are acting as adversaries to each other, and often that adversary degenerates into become enemies. Now, how does it go? Each side tries to convince the judge that they are right. Okay? But actually it translates to each side tries to convince the judge that the opponent is wrong. Actually, I want to prove that Tapi is a perennial river. But how can I do that? I have submitted my written evidence. And I can only answer those questions which are asked. The questions which are not asked cannot be answered. My opponent submits say evidence that Tapi is not a perennial river, and I try to prove his expert wrong. Similarly, my opponent's advocate tries to prove me wrong. So actually, if you really look at it, the parties are not proving what they are saying is right. The parties are proving what the opponent is saying is wrong. And I consider that not quite the way it was perhaps intended. The case is more, the entire proceedings are more on the technicalities. By technicalities, I mean legal, not technical in the engineering sense, than on merits. For example, supposing your opponent asks for 50 MCM as interim relief. Okay, how would you contest? Now, normally supposing if the chairman CWC or some officer in the CWC was the adjudicator, the chairman of a committee to decide, he may seek questions like, or the side may question it like, well, they asked for 50 MCM, but they don't need 50 MCM. And you try to prove that they don't need 50 MCM. You will try to prove that 50 MCM isn't in fact available. You may also try to prove that, well, it is available, but actually you need it more than the opponent does. Now, these are all called merits. We are going into the merits of the case. But that is now how it will be contested in the tribunal. In the tribunal, the first point will be raised is the tribunal does not have powers to grant interim relief. Then for next couple of months, they will go into great detail. What is the jurisdiction of the tribunal, whether they have the power to grant or not grant interim relief, what was said by the US Supreme Court in the case of California versus Nevada. So you see, you are really not going into whether 50 MCM is needed or not needed. You are not going into 50 MCM is available or not available. You are going into purely into technicalities. Then they will say application for interim relief is not maintainable under section A clause B of blah 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 and so on and so forth. So the proceedings tend to be more technical rather than on merits. That is another thing that needs to be looked into. The very format of cross-examination is unfair to the expert. And now this I am saying from personal experience of having undergone cross-examination at length on 3 different topics and 2 different occasions. And it lasted typically 10 to 12 days by Karnataka on one topic and so on and so forth. It's a very exhaustive process. It actually physically and from emotional, nervous energy also, it exhausts you. What happens is that the examining advocate will ignore all that is right. He will only try to highlight and show everything that is actually wrong, and he will also try to show as wrong whatever is not even wrong. And this is inevitable because the two sides are poised as adversaries, which is where I showed that initial slide that our system is adversarial system. Now see how it goes. It is very easy. In my study, there are many components, right? Supposing I have made a yield study. So there will be selection of rainfall stations, statistical checks to select or reject the rainfall stations, duration of time series. Should I use data from 1965 or 1985 or whatever? Runoff factor, acceptable limits. Should I reject the points with runoff factor higher than 0.65 or higher than 0.68 or whatever? So many things will be there. All these are my judgments. These are my opinions. Everything will be questioned, which is fine. Question it. That's what I'm here for. But the way it is questioned, okay? The procedure is weighed against the witness. The examining advocate does not have to prove his point. He only challenges the witness to prove his point. And if the witness cannot prove his point, then it is taken as if the point was wrong. And he deliberately will do so on the points that cannot be proved. Let us look at it with a hypothetical example. Okay? Selection of rainfall stations. Supposing I am doing, let us say, yield study in Haryana, and I have not used the rainfall station at Rohtak. Now the question will be asked is, you have not used the rainfall data of station Rohtak. Why have you ignored the data of station Rohtak? Look at the language. I have put it in the square bracket, ignored. I have not ignored Rohtak. I have rejected Rohtak. Oh, there is a huge difference legally. I have carefully examined the data of Rohtak, found it unreliable, and I have rejected it. And he very well knows it. But he will use the word, why have you ignored the data of the station Rohtak? So I will say, I have not ignored the data of station Rohtak. I have checked the rainfall data at all the stations for consistency. Details of the consistency check are at page P1 to P2 of my report. Data of Rohtak did not pass the consistency check. Therefore, I rejected it. I did not ignore it. Now, you would think that he should go to page P1 and P2 and look at my consistency check and grill me on that. No, he will not do that because he knows that if he goes to page P1 and P2 and looks at my consistency checks, I have applied them correctly. So no point going into that because that is right. He will not go to that. The next question could be, can you quote any scientific paper that says rainfall data at Rohtak is inconsistent? Obviously, I cannot quote such a paper. So my reply will be, I do not think that is possible because it would be extremely rare for a hydrologist to publish a paper merely performing consistency checks at various stations. Such checks are performed only as a part of a hydrology report. Since you say it would be extremely rare, so you do admit the possibility that someone may have published a paper as to whether the rainfall at Rohtak is or is not consistent. Look at the way the question is drafted. I am asked, can I produce a paper which says Rohtak data is inconsistent? I say that I cannot produce such a paper. No, I cannot say no one has written such a paper. How can I say that? Somebody might have written. So my language is, it is extremely rare for somebody to have written such a paper. That is used to twist it. Since you say it is extremely rare, so you do admit the possibility that someone may have published. Yes, such a possibility cannot be denied. He hands over some paper to me published in some seminar or some place. This is a paper on water resources assessment in Haryana, written by X, an eminent professor. He has used the data of Rohtak. What do you say? Witness says, well, X is an agronomist, not a hydrologist. This is not published in a, this is published in a seminar where the level of pre-publication scrutiny is very lax. In any case, he has not given any details of the statistical checks he performed. See, in a seminar, when we submit a paper, we don't give all the statistical checks and all that thing. We just either use or don't use the data. So he has not given the details of any statistical checks, whether he has performed, if any, before using that data. So we cannot infer that he has examined and found the data consistent. Finally, if X has used that data, that is his opinion. I do not agree with him. As an expert, I stand by my judgment that the data at Rohtak is inconsistent, the basis of which are explained, and I again repeat, the basis of which are explained at page P1 or P2 of my report. But again, he ignores that and he will ask, despite admitting the possibility that someone may have published a paper on consistency of rainfall data at Rohtak, you are not able to produce any such paper in support of your contention that the rainfall data is inconsistent. When confronted with a study where data of Rohtak has been used, you try to discredit the study as it is not by, he is not a hydrologist and it is his opinion. And eventually it typically ends with, I put it to you, that you have very deliberately not used the data of Rohtak because you are aware that if the data of Rohtak was used, the outcome will go against your client's interest, and you are declaring the data of Rohtak as inconsistent. It's just a fabrication for convenience. What do you say? What can you say? A simple accusation has been made that you are simply fabricating this, that Rohtak data is inconsistent, repeatedly ignoring your plea that please look at page P1 and P2 where the consistency checks are given. And this is just a typical, though hypothetical, but a typical example. This is how the cross-examination proceeds. So let us analyze these sections. He never refers to the consistency checks in the report. He carefully asks the questions that can only get the answers in his favor. He never says the data is inconsistent. Okay? I am saying the data is inconsistent. He never tries to prove it is consistent. But my inability to produce another independent paper to support my opinion is used to paint a picture that there is something incompetent and something sinister in my rejection of the Rohtak data. And the entire, or I would say most of the cross-examination proceeds in this favor. Typically at the end of the day, 4 o'clock, your blood is boiling for not being able to say what you want to say, because as a witness, you are not allowed to say anything. You only answer the question that is asked to you. You cannot answer something which is not asked to you. Third, technical questions are treated as binary, true or false. Now, that might be fine in criminal trial. You know, in criminal trial, things are facts and they are either true or false. For example, the accused was present at the site of the crime. He was present or he was not present. True or false. The bullet was fired from the gun owned by the accused. True or false, and so on. Fingerprints found at the site match those of the accused. True or false. So everything here is true or false. But that is not the case with hydrologic study. This point, the graph used, this is a scatter diagram typically. This point is an outlier, true or false. Now that point you see in the circle. Can you say, can you treat this situation that it is true or false? Some hydrologists might think that this point is an outlier. Some hydrologists may not think so. These are not facts, these are opinions. And you cannot treat them in the manner true or false. But what will happen is, it will be treated as true or false. So if I had treated it as true, I will be challenged to prove it is true. No, I cannot prove it is true. It's my opinion. And because I cannot prove that to be true, it will be taken as if it is false. Conversely, if I have said something as false, again that will be challenged in the same manner. Or take another thing. Crop water requirement of paddy is, suppose in somewhere in my report I have said, crop water requirement of paddy is 550 millimeter. Now, can you treat this question as true or false? You look up the internet, Google, you will say that you will find crop water requirement for paddy in India may vary from 450 mm to 700 mm, depending on many situations. A might say it is 450 mm, B might say it is 500 mm, C might say it is 550 mm. But none can be proved right or wrong, because true and false applies to a situation of fact. Crop water requirement is not a matter of fact, it's an estimate, it's an opinion. So a technical study comprises several subjective opinions which can't be examined as true and false. Fourth, the entire study is also treated as a binary, and it either stands or falls. Now, technical domain doesn't work that way, does it? Supposing, how do we do it in the technical domain? Supposing you are Chief Engineer Hydrology in the CWC, I come to you with a DPR. In the DPR, there is a chapter on hydrology. You examine the chapter and you agree with some, you disagree with some. For example, say selection of rainfall stations. I have used 9, you agree with 8, but you disagree with 1. Filling out the missing data, you agree with everything. Duration of the time series used, you agree with everything. Crop water requirement, again you disagree. I have used 550 millimeter, you disagree and you want something else. So what would you do? Obviously, in a technical domain, what you would do is you will ask me, Mr. Pandit, go back, remove that one station which I don't agree with. Crop water requirement from 550 mm, make it 500 mm, rework your arithmetic and come back again. You won't say that because your report is uses a station data of a station that I don't agree with, it uses a crop water requirement that I don't agree with, therefore your report is hereby rejected forever, don't ever come back to me again. No, that is not the way the technical domain works. But that is the way a court works. Here there is no redo. It's a sudden death scenario. By sudden death, that's a term borrowed from sport, like in a cricket. A batsman makes one mistake and gets out. There is no thing like in table tennis or badminton, you lose a point, doesn't matter, you play on. That is not the case. It's a sudden death scenario in cricket. Similarly, here it's a sudden death scenario. You make one mistake is found in your report and it's over. You can't say, all right, sorry, I used the data of a station which I should not have used. Just give me one day. I will go back in the evening, correct the arithmetic and come again. No, your report is gone. You are gone forever. So this binary treatment of the report is again not quite correct, suited. Expert witness. We are called expert witness, but are we really expert? Are we accepted as expert? If everything that I say has to be proved, then what kind of an expert I am? At least don't call me an expert. My hydrology, my design cert, my agriculture and demand, everything are sworn affidavits, evidence, and are evaluated as per the Indian Evidence Act. Now, going away from the hypothetical example, I will give you a real example. In my cross-examination on the Mandovi River, at one place, the CWC GD site, CWC had observed the data for some period by float method. Now, we all know that float method overestimates the velocity and therefore the discharge. And I used a correction factor of 0.84. BIS code allows everything from 0.79 to 0.92. So I used a correction factor of 0.84 to correct that data. Now the questions were, had CWC already corrected the data, or was I applying, am I applying the correction a second time? Second, I have used the correction factor 0.84. Is that right? Or should it be at 2? Or should it be at 6 or whatever? But no. The first question asked to me was, prove that float observation requires a correction at all. And that was right at the beginning of the cross-examination. I was asked, anybody who knows even the slightest of river observations or river hydraulics knows that float data overestimates the velocity. And I was surprised that I had to prove it. And if this also I had to prove, then what kind of an expert I am? Fortunately, I was aware that there is a BIS code on that. So I was able to produce the BIS code and prove that you had to apply correction factor. Only then it proceeded to what should be the correction factor. So we are called expert, but nobody really accepts us as expert on anything. So what happens then? Now we are coming to the end of stage 2 of my presentation. A's advocate shows that B's basin planning deserves to be summarily rejected. B's advocate shows that A's basin planning also deserves to be summarily rejected. So eventually, at the end of the entire cross-examination by both the parties, we know what all may be wrong. And I'm saying may be wrong. That doesn't mean necessarily wrong, but it could be wrong. But we still don't know what is right. क्या गलत है ये तो सब लोगों ने दिखा दिया, सही क्या है वो तो किसी ने नहीं दिखाया. Then what? Say for example, 75% dependable yield of Yamuna and Okhla, on reasonable requirement of state X, on groundwater availability of state Y, or whatever. Everyone proving everyone else wrong. So then nothing. When everyone has proved everyone else wrong, you are left with nothing. And then, with the help of the tribunal assessors, the tribunal will of course come to some conclusion. But this can be improved. It doesn't have to be this. So let us in the last part look at some ways by which things can be improved. Now, some of these are out of the box ideas, and the advocates particularly would be aghast at some of these ideas. But these are my ideas, which you can say, culled over something like 7 years in Mahadai, 2 years in Mahanadi, something like 9 years, and being right in the battlefield, in the bunker, not observing from the sideline. First of all, it would be very nice if the river water dispute tribunals adopt an inquisitorial method and not the adversarial method. How can that be achieved? Say, for example, cross-examination is an exercise in fault finding. There should be no cross-examination. That does not mean that whatever study I submit should be accepted as gospel truth. Of course not. Because my opponent is going to submit a study which is going to be different from my study. So nothing is gospel truth. But technical study should be discussed. I have submitted a technical study. I have spent a lot of time, drawn many graphs, double maskers and this and that before coming to the conclusion that Rohtak data is inconsistent and this has to be rejected. Discuss it with me. Allow me to explain why it is inconsistent. Don't simply ask me to produce some paper, and if I can't produce a paper, then I'm wrong. But that is what will happen in a cross-examination format. So cross-examination is an exercise only in fault finding and does not help anyone to reach the truth. Tribunal may be asked to, of course, may ask the question to the expert witness, because that is not cross-examination. The opposite side may have objections to my study. Fair enough. If the hydrologist advising the opposite side really feels that Rohtak data is consistent and should be used, then they may submit their objections to the tribunal in writing, but no oral cross-examination. Because the moment you make me stand in the witness stand and subject me to an oral cross-examination, it is going to degenerate into the kind of example that I showed you, where everything, all my analysis will be ignored and only some pointless questions will be asked, produce this and produce that. If at all cross-examination is allowed, at least can we not change the format? Presently, what happens is there are two things that can be changed. First, presently what happens is questions are asked one at a time. One question is asked to me, I answer it, then it goes to the second question, and I may take 2 minutes more. I have already taken 50 minutes. I will finish in another maybe 10 minutes. Let me describe you how actually this cross-examination is conducted. I stand at the witness stand. There is no actually witness stand the way you see in Hindi films. Some tribunals are very nice. The Mahadai tribunal was very nice. They allowed me to sit on a chair. We are all past 60. But I am told in the past there was a tribunal which did not even allow Professor Subhash Chandra of IIT Delhi to sit. He was made to stand all the day. Finally, he was past 65 or something, and he requested the tribunal that can I at least sit? And he was told no. Anyway, so I am there at the witness stand. Besides me sits a steno with a computer which is connected to a LCD projector, and the question as well as the answer, my answer as I dictate it, are projected on the screen for entire courtroom to see. I can dictate an answer, I can read it again. I can make changes, change my words, change the numbers, comma, full stop, anything. I can even delete the entire answer and rewrite it all over again. Everybody will patiently allow me to do that. But once I say over or thank you, it is kind of locked. आपका आंसर लॉक कर दिया गया. और एक बार आपका आंसर लॉक कर दिया, now you cannot come back and change anything. This doesn't really test only my knowledge. It tests my ability at quick thinking. Supposing I might be a good hydrologist, but I may not be very witty. I may not be quick thinking. At that point of time, I may be nervous because I'm aware that the entire team of the state I'm representing is looking at me, and they are aware that one mistake I make and they will be kind of feeling defeated. So I'm nervous. What are you trying to test? Are you trying to test my nervous energy, or are you trying to test my knowledge of hydrology? Submit all the questions to me in writing. Give me 2 days. In any case, in the cross-examination, I am allowed to refer to any document, any book, any report, anything. It's an open book exam. So if it is an open book exam, give the questions to me in writing, allow me to take them home, and I will submit all the answers in writing as a sworn affidavit. So that is another change we can make. Alternatively, at least it should not go sequentially. That means, supposing question number 5 I answer in some way, but after some 10 questions I realize that I made a mistake there. Allow me to go back and correct that mistake, because after all you are testing my knowledge. Yeah, there was something in the chat box, so I just read what it is. Okay, so we can change the format of the cross examination. Change it to questions to be submitted in writing. Give the witness a reasonable time to submit the answers in written answers, and test his expertise, not test his wits or his nervous energy. Water dispute tribunal should be constituted on the lines of NGT, where there are legal experts and also technical experts. I believe this was considered when the bill, which is presently pending before the parliament, was drafted. But for some reason, it was dropped. Now, it so happens that for some reason, I attended several hearings of NGT also. And I find they are much less formal than they are much less formal than the proceedings in the River Water Dispute Tribunal. There is a technical member, there is a legal member, and they don't go so much on the technicalities. Further, you don't have to be an advocate to argue before the NGT. Anybody can argue. I mean, even the complainant himself can argue. So, the Water Dispute Tribunal should be constituted on the line of NGT, where there are the members constitute legal experts, also technical experts, maybe socio-economic experts. Why not? Because the resolution of a water disputes has a lot of, you can say, bearing on the socio-economic status of various parties and how the water allocation may affect them. So it should be constituted with other experts also. There are some questions popping up in the chat box, but you will kindly excuse me, I can't read them now. I hope it will be visible to me once I stop sharing the screen. Okay, I'm just about to finish now. Draft reports. Now, I tried this suggestion with some of the advocates, and they thought that I have gone crazy and I need to be sent to a mental asylum or something. My suggestion is, why can't the tribunal submit a draft report? Why is it that in the end they submit a report, and then if anybody has anything to say, the only thing he can do is go to Supreme Court? Actually, law doesn't even permit that. We are coming to that. Law doesn't even permit that. But since Kaveri, a practice has started, then it was followed in Mahadai also, that the parties appeal to the Supreme Court under the special leave petition format, right? Point is, anyway, one way or the other, the law says that the award of the tribunal is final. Now you are allowed to ask clarification. Supposing in the clarifications you find something which is indeed needs to be corrected, but you can't say it should be corrected because that is not a clarification. So in the tribunal, in the Mahadai tribunal, we have passed the stage. The Mahadai tribunal has given their award on 14th August 2018. Then we all submitted our request for the clarification, and some of the requests for the clarifications are in a language like this. The Honorable Tribunal may kindly clarify that. And what follows is actually not a clarification, but a request for modification. So why are we forced to do that kind of a trick? The tribunal should simply allow us, the law should allow us to submit any objections or anything, the modification we want. The tribunal may modify the award thereafter. Finally, the tribunal is all powerful. Their award finally will be final and binding on all the parties. That goes without saying. So either the tribunal may give a draft report, just that they give the draft issues. They give the draft issues, we discuss it, we suggest modification, but of course the judges have the power to decide the final thing. Similarly, they have the power here also. So let them give the draft award, let it be discussed, or they can give an award, but there should be an opportunity to appeal within the tribunal itself. Either way, it comes to the same thing. Award once given should not be final and binding at that stage itself. There should be at least one round of a review within the tribunal. This will save the Supreme Court from being burdened with the SLPs. Okay. Finally, the time. The last issue. Only the end time limit. No tribunal has given the award in the 3 hours that are allowed. Please understand that the time allowed in the present law is not 5 years, it is 3 years. But it can be extended by 1 year each twice. So it really becomes 3 years allowed plus 2 years of extension. No tribunal has ever finished the work in 3 years. And even 5 years is a rare case. Mahadai and I think Vamsadhara, they did finish in 5 years, but that is just recent case now. Everybody has taken much more than 5 years. How can we change that? How can uh, how can we enable the process to be finished in the given time? Now, what I find very surprisingly is that the new law proposes 2 years plus 1 year. That is, you finish in 2 years plus 1 year extension. Now, I'm completely bamboozled by this. I find it incomprehensible. If I'm not able to do a work in 3 hours, so you are saying that अच्छा तुम 3 घंटे में नहीं कर सकते तो चलो 2 घंटे में करो. ये क्या लॉजिक हुई भाई? Unless you go into why am I not able to finish it in 3 hours, you can prescribe 2 hours or 1 hour or half an hour, nothing will change. Now, if there has been any thinking behind this reduction of time from 3 years to 2 years and from two extension of to one extension only, if any thinking has been there, at least it is not revealed in the public domain. I am not aware of any such thinking. Now, this is what happens probably when such changes are proposed by people who have themselves not been a part of the tribunal process. Now, how to enable the tribunal to adhere to the time limit? The method is very simple, and all of us follow the same thing in our daily life. Make a PERT or CPM chart or a bar chart. Supposing after this lecture, which I should finish by say in few minutes, supposing I am required to go to Pune airport and catch a flight. How do I ensure that I do it in time? Flight is at 4. I work backwards. Flight is at 4 o'clock. So reporting by 3 o'clock. My travel time from my home to airport is about 1 hour. So I must leave home by 2 o'clock. Allow 15 minutes for any unforeseen puncture in my cab, etc. So I must leave home by 1:45. I must have lunch. So I should finish the lecture by 1:30. And so on I go. I work backwards. And then I keep a time check time to time. Oh, it's 1:15. I have still not finished the lecture. I have to finish the lecture, answer questions, have lunch and rush to the airport. So I may make some adjustment. That is the only way to do it. But in the tribunals, what is happening is, let us say it is a time limit of 5 years. Let us say that the 2 years extension is kind of given. So there is no, you can say, PERT or bar chart or CPM chart as to by what time you should finish various stages. Now, in the process which I described to you, I have explained various stages: completion of pleadings, framing of issues, supplying of data as per interrogatories, submission of affidavits, recording of evidence. Prescribe a time limit to each of that. Pleading should be completed in 1 year. Framing of issues should be done by end of 18 months. Supplying of data as per interrogatories by 22 months or something like that. And then as you proceed, keep a check. But that is not happening. What is happening is that there is only an end time limit. And you know what will happen? If I have to catch a flight at 4 or 5 o'clock, but I do not go reverse engineering and do not make a timetable of various stages, then at 4:30 I will realize that only 30 minutes are left and I'm still giving a lecture. So, such things should be either prescribed in the law itself, or the tribunal may kindly be requested that please, your lordship, make a timetable right at the beginning and then let us proceed as per that timetable. Another procedure is, another step that I can think is, 50% of the time is taken in pleadings only. SOC, reply, rejoinder and all that. Sometimes the tribunal may even allow a revised SOC. And half the time is taken in that. Why should all this be done during the, you can say, incumbency of the tribunal? Because in this period, the tribunal actually is not doing anything. We are all just working in our barracks and we are writing the pleadings or the replies or the rejoinders. So instead of just a complaint, the law can be amended to say that when a complaint is received by the Ministry of Water Resources and the Ministry of Water Resources feels that the dispute cannot be resolved amicably, they should ask all the parties to submit their SOC and give a time limit for that. On receipt of the SOC, all parties should be asked to write a reply. On receipt of the reply, all parties should be asked to write a rejoinder. So complete the pleadings here. And these pleadings should be also asked to be in the same status, that is sworn affidavits. And once the pleadings are completed, only then let the tribunal start the work. So you would have reduced about 50% of the time. So like that, there are some ideas, but I think I have taken a lot of time. That is not all that I wanted to say. There is plenty more. But I am constrained by two things. Number one is, of course, time. Eventually, everything has to end in a reasonable length of time. And also, there are certain things on which I cannot speak too openly. Not now, maybe someday later. Okay. So that is all for now. Thank you very much. And now I don't know how to proceed. Should I read the check? I will stop sharing the screen.